California Senate Bill 1437 is a huge change in California criminal law that goes into effect in 2019. So let's talk a little about what it is and whom it might affect. California Senate Bill 1437 is a California criminal justice reform law that changes the felony murder rule. For decades, in California and around the nation, people have been handed life sentences in first-degree murder convictions because of the felony murder rule, even though they never killed anyone. Senate Bill 1437 finally fixes this injustice.
Felony murder is a concept in criminal law that allows prosecutors to obtain convictions for persons who were involved in certain enumerated felonies when someone was killed during the perpetration of that felony. It's easier to understand with an example. Let's say, for example, person X was the getaway driver for a planned robbery. Persons Y and Z are the actual robbers. Person X was unaware that persons Y and Z were armed. Let's say person X stays in the car as planned, and persons Y and Z exit the car and commit the robbery. But then things go south, and person Y kills the victim of the robbery. Even though person X was unaware that person Y was armed and was not involved in the killing in any way, person X can and most likely will be convicted of first-degree murder under the old felony murder rule because person X was involved in the underlying robbery. The felony murder rule applies to several felonies, the most common of which are burglary, arson, kidnapping, and rape.
So how does Senate Bill 1437 change felony murder? What 1437 does is it changes the definition of murder such that person X, in our previous example, may no longer be convicted of murder. Senate Bill 1437 does not completely do away with the felony murder rule. For example, the person Y who actually perpetrated the killing can and most likely will still be convicted of first-degree murder. However, what 1437 does is it limits murder liability for accomplices in the underlying felony, like person X.
If someone has been convicted of first-degree murder under a felony murder theory, that person will be eligible for resentencing. In most cases, what that means is the person's murder conviction will be overturned and they would be resentenced on the underlying felony. In the example we gave earlier, that would be robbery. In most cases, this resentencing will cut years off of someone's sentence, and in certain circumstances, it may result in immediate release.
Determining those who are eligible for relief under Senate Bill 1437 is actually a fairly complex issue and requires thorough investigation. However, there are three broad categories of people who may be eligible for relief. First, those who were convicted of first-degree murder under a felony murder theory. Second, those who were convicted of second-degree felony murder. And third, those who were convicted of second-degree murder under a natural and probable consequences theory. Taking a plea or pleading guilty does not necessarily disqualify you from eligibility under Senate Bill 1437. In fact, the bill specifically states that if you took a plea, you could still be eligible for relief.
Filing a petition to vacate a conviction under SB 1437 seems straightforward on paper, and in fact the courts have even provided a form for you to fill out. However, where the real challenge is going to lie in these cases is litigating the petition. The California District Attorneys Association vehemently opposed these changes in the law, and we expect that they're going to be fighting us every step of the way. In order to best preserve our clients' right under SB 1437, we work up every case in anticipation of zealous opposition. This includes gathering court records, transcripts, police reports, and in some circumstances even witness declarations. The statute puts in place timelines for filing the petition and for briefing. Under the timeline, the process is to take approximately 90 days at its fastest. However, in the early days of the law going into effect, it would be reasonable to expect delays as the courts and prosecutors attempt to figure out the process. The law goes into effect January 1st, 2019. Now is the time to get started on your case to get you the fastest relief possible.